greater details on those matters. Thank you.
Honourable Leanne Dalziel.
Chairman, I do want to reflect on one particular clause of the legislation, and perhaps I should preface my comments by sort of making the point that none of the current members for Labor on the Justice and Electoral Committee were on the Justice and Electoral Committee when this legislation went through. So we haven't actually had the benefit of a discussion with officials over the intent of the particular part that I want to raise. And I've also had a brief conversation with Dennis O'Rourke, who I know is going to be taking a call on the same matter, because he has an amendment to this particular clause, which is in relation to his supplementary order paper number 33, which promotes deleting new section 15A2 in clause 10. And the reason that I want to focus on this is that I actually am not aware of the reason behind it. And I think it would be incredibly useful if the Minister could give us a description as to why the legislation, which has been promoted for one particular purpose, which has had some publicity in relation to the example that my colleague David Clark already provided. But this particular section, which requires the registrar to excuse a person summoned to attend as a juror on an occasion from attending in any court on any occasion if satisfied, on a written application for the purpose made by or on behalf of the person that the person is or over the age of 65 years. And so that's a permanent excusing from serving on a jury, and the only satisfaction of the criteria that is proposed by this clause is that the person is 65 years or older. And of course, there's been a lot of discussion about how we have dealt with a somewhat ageist society, and many changes that we've promoted in this House actually take away discrimination based on age. And it seems to me that this would, having age 65 as a criteria in a standalone basis, actually probably it seems to me to offend the principles of all of the legislation that we've promoted in terms of human rights, to remove age as the basis or a delineating point for anything other than, entitlement to, say, for example, superannuation, as it still is in this country at the moment. But I think that it is worthy of some further discussion, because when we had our representatives on the select committee that heard the evidence on this particular bill, they felt that there was a concern about the age of 65 being used as a means, and I'll just quote from the report back from the Select Committee. The Labor members are concerned that extending the registrar's power to grant permanent excusal solely because a person is 65 or over is at odds with progressive measures advanced over recent years to eliminate ageism and stereotypes and to promote participation. And then they go on to say that the bill doesn't actually propose to reintroduce an age limit for jury service, and that's the whole Select Committee commenting at that point. So simply saying, well, Labor's concerned about it looking like there is a bit of ageism creeping back into the law, but saying, no, this isn't a cut-off point. And then talks actually about the fact that they don't consider, again, this is the whole committee, not the Labor members alone, that what is proposed implies that older people are less capable of serving on a jury. On the contrary, we consider that the life experience of older people is of significant value to society, and we would encourage those who are able to do so to continue to undertake jury service. Well, I actually think that there's a little bit of a conflict in this, and this is what I would like the Minister to debate, because I'm actually thinking that on our side of the House we should be supporting the amendment put forward by Dennis O'Rourke. On the face of it, it actually does look as if we are putting in place a particular provision, if it were taken up by everyone over the age of 65. I don't know how many juries we'd actually avoid having, Mr Chairman.
Honourable Leanne Dalzell.
Mr Chairman, I don't know how many juries actually wouldn't be able to be impanelled under those circumstances, because I have to say that, and I don't spend a lot of time down at the courts, but the odd time that I've been in there for a jury trial, there would be more than one or two who would be over the age of 65 sitting on any one jury. And I think that the concept of just simply having somebody having age as the basis for a permanent excusing, and it does appear that it doesn't even require them to ever having served on a jury. So as long as you get to 65 and have never been called to give service on a jury, then just by notifying the fact that you're 65 and do not wish to be ever called, you would never do what I consider to be a duty to the wider community in terms of serving on a jury. So it does seem to me to be not in full accord really with the intent of the legislation as it was originally promoted. I mean, the original reason for promoting this legislation was the concern that had occurred in relation to a self-represented accused who corresponded with persons whose names and addresses were on the jury panel for his trial. Now, I don't think anyone's got any objection to that particular part of the legislation. It's this other part that doesn't seem to be connected with that in any way, shape or form, and I know that it doesn't have to be for it to be legally within the scope of the legislation, but it does seem to me to be taking advantage of a particular piece of legislation that's established for one purpose to in fact provide for another. And I really cannot for the life of me understand why it is that age would in fact be that threshold on its own, despite the fact that the person may never have provided jury service in their entire lives. They may have not been called forward, they may not have been able to, they may have had a specific reason to be excused from jury service in a particular trial, having a conflict of interest, whatever. But that person then, just because they've become 65 years of age, are able to write for a permanent excusal, and that doesn't seem to make much sense to me. But then, as I say, it was because none of us actually sat on that select committee when the bill was referred to it. So even though it's a relatively small bill and that we are supporting the passage of the bill, it does seem to me that Dennis O'Rourke has a very good motive in terms of promoting his supplementary order paper, and I will be interested to hear his comments, obviously, as the promoter of that particular amendment, which would delete the relevant clause. But I would like to hear from the Minister in terms of how this particular clause came to be, and I know that it was introduced under her predecessor, the Honourable Simon Power, yet another piece of legislation the Minister's had to pick up in that regard. But I'm sure that she's read the background briefing papers to it and will understand and will be able to explain to the House why this particular clause is so important. And if it is not, if it is actually not that important, and if it really, doesn't need to proceed beyond here, then perhaps the Minister may be willing to consider Dennis O'Rourke's supplementary order paper, which would remove it from the legislation. And I guess my last question would be, what effect would that have? Would that impact on any other elements of the legislation that are proposed? And if it would have such an effect, perhaps if the Minister could just simply explain that, then I think that would be very useful in terms of how we would vote on the supplementary order paper to which I referred. So, Mr Chairman, just really in summary, I think the Labour opposition will be supporting the bill. We have had a rethink of the position that our committee members did signal when they sat on the select committee in light of the fact that Dennis O'Rourke has put up a supplementary order paper. I mean, he clearly wasn't a Member of Parliament at the time that the bill was introduced, so he's brought some fresh eyes to the subject, as I think new members of the Select Committee have brought to the subject as well. And I'm certainly hoping that we can get to an understanding of why this particular provision was considered to be necessary by the previous government, whether it is still considered necessary by the current government.
The Honourable Judith Collins.
Mr Chair, I understand that both of the previous speakers